It feels like every day there's something new to try to get your head around, trying to keep up with it all, figure out what really matters. It can be exhausting.
It really can.
So we're trying something a little different here. Welcome to the deep dive. This is where we try to make sense of the stuff you care about, but quickly, right? You give us the info and we boil it down to what you really need to know.
Exactly. Today we're diving into some pretty significant Supreme Court of India rulings, decisions they made in 2024. You've given us, well, a whole bunch of these judgments to
And
look
lots
at.
to cover.
Yeah, and our goal is to pull out the ones that really pack a punch and explain what they mean, but without getting lost in all the legal mumbo-jumbo.
Exactly. We respect your time, and we're here to break it all down clearly and hopefully in a way that makes you think, huh, I get it now.
That's the goal.
All right, so where should we start? Well, let's jump into this thing about interim stay orders and how long they can actually put things on hold.
Okay, so this is interesting because the Supreme Court actually revisited, kind of changed its mind about a rule it had set earlier.
Oh.
Yeah. There was a case back in 2018 called Asian resurfacing, and that basically set a precedent. The rule was that any interim stay order, which is like a pause button on legal stuff, would automatically expire after 6 months unless there was a good reason to extend it.
So like a built-in time limit. If things weren't moving fast enough, boom, the pause was gone.
Right. But now that's changed. In 2024, in the High Court Bar Association, Allahabad versus State of UP case, the Supreme Court reversed that automatic expiration. So the rule now is that stay orders, and this applies to civil and criminal cases, will stay in place until the court actually decides the case.
Wow, that's a pretty big shift, isn't it? Why the change of heart?
The court basically said, look, delays happen, and they're not always someone's fault. These delays could be because a case is complex, or the court is just overloaded, or maybe one of the parties is dragging things out. Yeah. So the court felt that the automatic 6-month rule was sometimes causing unfair problems. It could really disrupt things just because of the calendar, not because a judge had looked at it and said, yeah, this stay isn't needed anymore.
So no more poof after 6 months. It sounds like that'll make things a lot more predictable for anyone involved in, lawsuits or legal battles.
Definitely. And this applies across the board
Yeah.
to civil cases, like disputes between people and criminal cases too.
Right.
So for you, the listener, the big takeaway here is more stability when a stay order is in place. You can pretty much expect it to stick around until the case is decided, unless the court specifically says otherwise.
Got it. Okay, let's move on to something that I know caused a lot of buzz. The electoral bond scheme being struck down. This was the Association for Democratic Reforms versus Union of India case, right? Can you break down what the big issue was there?
Sure. The main question for the court was whether allowing political parties to get money anonymously through these bonds, was it violating citizens' basic rights? Like their right to know, to have transparency, which is part of freedom of speech, under Article 19(1) of the Constitution.
Yeah.
And they were also looking at whether this anonymity was messing with free and fair elections, like giving an unfair edge to parties in power or big donors who could just pour in money without anyone knowing.
And the Supreme Court didn't hesitate, did they? They just straight up said, this whole scheme, it's unconstitutional. What were their main reasons?
Well, they concluded that the scheme definitely violated that right to information, Article 19(1)(a). They basically said, look, for voters to choose wisely in an election, they need to know who's funding the parties. It's about seeing potential influences, any biases that might be at play because of the money. But these anonymous donations, they kept everyone in the dark about a really crucial part of the political game.
Yeah, it makes total sense. If you don't know where the money's coming from, it's harder to see what the party might be beholden to, what their priorities really are.
Absolutely. And the court went further. They said this scheme was arbitrary, meaning there wasn't a solid reason for it, so it violated Article 14, which is all about equality before the law. And they also decided that this lack of transparency was bad for the whole democratic system.
I can see that. So what happened then?
The court told the State Bank of India, the SBI, you have to tell the Election Commission everything. Who bought these electoral bonds and which parties got the money.
That's a big step toward, shining a light on political financing.
It is. And the court really hammered home the point that free and fair elections and transparency in funding, those are core parts of our Constitution, like foundational stuff that can't be messed with easily. So for you listening, this judgment really aims to open up the process of how parties get their money, which is super important for a healthy democracy. We need to be able to make informed choices.
Now, we just talked about the right to know, right? But another case in 2024, Kariko Cree versus Nuni Taiyang, kind of put some limits on that right. particularly when it comes to what election candidates have to disclose about their personal stuff.
Yeah, this is about finding a balance, right?
Right.
The court said, yes, voters need information about candidates, but candidates also have a right to privacy. They were specifically looking at the rule that candidates have to disclose their assets, what they own, when they're running for office. They clarified that this rule mainly applies to things that are, significant things that really matter.
So not every little thing they own. Like, I don't need to know if a candidate has a collection of, I don't know, thimbles.
Exactly. No thimble disclosures needed. The court made it clear. You don't have to list every single little item, especially things that can be moved easily. What matters are those big assets, or maybe big debts, things that could actually swing an election or that show whether the candidate has conflicts of interest, stuff like that.
Things that could actually affect a voter's decision, not just random stuff in their attic.
Right. It's about finding a balance. We need transparency so voters can make informed choices, but we also have to respect the privacy of people who are running for office. So for you, the listener, this case gives you a clearer idea of what financial information about candidates is really important. It's about the big picture, not the small stuff.
Let's switch gears for a minute. Let's talk about families and a really sensitive area. The 2024 case of Karl Ramnesh Pal Singh versus Shigandi Agarwal, which brought up this idea of parental alienation syndrome. What did the Supreme Court say about that?
This case was about child custody, and the court specifically pointed out that they saw signs of parental alienation syndrome in the children involved. This happens when, a couple splits up, things get messy, and one parent tries to turn the kids against the other parent, by bad-mouthing them or making it hard for them to see the kids.
It's just awful for the children stuck in the middle.
It really is. And the Supreme Court was very clear. Don't do this. Intentionally poisoning a child's mind against their other parent. That's damaging, plain and simple. And they said, when making decisions about custody, the most important thing, always, is what's best for the child.
So what did they decide to do in this case?
They said shared custody arrangements are important whenever possible. Both parents need to be involved in their children's lives, and they stress that everyone has to stick to the custody schedule, the agreement about who gets the kids when. They also said counseling can be helpful for both the parents and the kids to work through all the difficult emotions. So this case really shows how much the court cares about protecting children's well-being when parents are fighting. It's a reminder that the legal system is there to try to shield kids from the harm that parental conflict can cause.
Now, moving on to the juvenile justice system, the case of child in conflict with law through Mother versus State of Karnataka from 2024 looked at how you can appeal decisions made by the Juvenile Justice Board, specifically their initial assessments. What do we need to know about this?
This case clarified how you go about appealing a preliminary assessment from the JJB. The court said these appeals are governed by Section 1012 of the Juvenile Justice Act. Initially, the law said you had 30 days to file an appeal.
So a pretty strict deadline.
Yes, but the Supreme Court clarified that this 30-day limit is more like a guideline, not an absolute rule. Think of it like this. A mandatory rule is like, you must do this, no exceptions. But a directory guideline is more like, you should do this, but there might be special cases where it's okay to be a bit late.
Right, because sometimes sticking rigidly to deadlines can actually prevent justice from being done.
That's the idea. The court wanted to make sure there's room for flexibility when it's needed. And they pointed out that this initial assessment by the JJB, remember, this is a huge step in figuring out whether a kid accused of a crime is treated as a minor or an adult in court. Well, it's not the final word. The Children's Court can review it and decide if it was right or wrong. So what they're doing is balancing the need for things to move along in a timely way with the bigger goal of making sure the child gets a fair outcome. What this means for you, the listener, is that there's a way to challenge that initial assessment, and the system allows for a bit of flexibility on the timing to make sure things are fair.
Makes sense. Okay, let's talk about another case from 2024, Frank Vitas versus Narcotics Control Bureau. This one was about that whole debate over making people share their live location as a condition of getting bail. What did the Supreme Court say about that?
So in this case, the Delhi High Court had granted bail to Frank Vitas, but said he had to keep sharing his live location, basically letting the police track him 24/7. The Supreme Court stepped in and said, nope, you can't do that.
Yeah, that does sound like a pretty big invasion of privacy.
It is. The court ruled that doing this violates the right to privacy, which is protected under Article 21 of the Constitution, the one about the right to life and liberty. They said that constantly tracking someone like this is basically like keeping them under house arrest, even though they've been granted bail.
So bail shouldn't mean you're constantly being watched electronically.
Exactly. The Supreme Court said, when setting bail conditions, you have to balance the state's interest in making sure the person shows up for court with the person's right to be free and have privacy. This ruling really emphasizes how important those basic rights are. It sets a limit on how much surveillance is okay, even for people out on bail.
Let's move to a landmark judgment that tackles social justice inside prisons. The case of Sukanya Shanta versus Union of India in 2024 dealt with this deeply rooted problem of assigning work to prisoners based on their caste. What did the court decide?
This was a huge decision. The Supreme Court said, flat out, that assigning prison work based on caste, unconstitutional, full stop. They said this practice violates a bunch of fundamental rights in our Constitution. The right to equality, Article 14, no discrimination based on caste, Article 15, the abolition of untouchability, Article 17, and the right to life and liberty with dignity, Article 21.
Wow, that's a pretty strong statement. So, what did they actually tell the prisons to do?
They gave a very clear order. Stop assigning those menial tasks based on caste. Things like cleaning, manual scavenging, all that. They said work in prison should be based on skills and what people are good at, and it has to be voluntary. They also said, get rid of all references to caste in your records. Delete those columns in your registers.
So, completely dismantling that system from the inside out.
Exactly. They told the state and union governments, revise your prison manuals, make sure they follow the Constitution. And to make sure this actually happens, they gave the district legal services authorities and boards of visitors the job of monitoring all this, going into prisons, and reporting any discrimination they see. This is a big step towards ending a practice that's been going on for way too long, sometimes even since the colonial days.
Moving on, let's look at another case from 2024, Garv Kumar versus Union of India. This one focused on those fees that state bar councils charged new lawyers to enroll, which some argued were way too high. What did the court decide about that?
So in this case, Gaurav Kumar said these enrollment fees were unreasonable and often way more than what was allowed under the Advocates Act of 1961. That's the main law about the legal profession. That act sets specific fees for joining the bar councils, and it doesn't say anything about extra charges.
But it sounds like some bar councils were tacking on a bunch of additional costs.
Yeah, that's exactly what was happening. The Supreme Court looked at it and saw that many state bar councils were adding all kinds of extra fees for libraries, welfare funds, administration, you name it. It was making it really expensive to become a lawyer, especially for those just starting out. The court's ruling was clear. You can't charge anything beyond what's in the Advocates Act. Stick to the rules.
That's got to be a big relief for a lot of new lawyers, especially those who don't come from wealthy backgrounds.
Absolutely. It makes becoming a lawyer more affordable, which is important for having a diverse legal profession. It also puts a stop to these regulatory bodies charging fees that they're not supposed to.
Back to family law now, and specifically the rights of divorced Muslim women. The case of Mode, Abdul Samad versus State of Telangana in 2024 dealt with the issue of maintenance after divorce. What was the main question the court had to answer?
The question was whether a divorced Muslim woman could ask for maintenance under Section 125 of the Criminal Procedure Code, which is general law about providing for wives, children, and parents who are in need, or was she limited to what's in the Muslim Women Protection of Rights on Divorce Act of 1986? Mode. Abdul Samad was challenging a high court order that told him to pay maintenance to his ex-wife under that general law, Section 125. He said she should only be able to go by the 1986 Act.
And what did the Supreme Court say about that?
They said Section 125, that general law, it's secular, it applies to everyone regardless of their religion. It's a safety net to prevent people from ending up destitute. So it covers Muslim women too. They made it clear that the Muslim Women Act doesn't stop a divorced Muslim woman from also seeking help under that general law. It's like having two different tools in your toolbox to get support after a divorce. So this ruling makes it clear there are legal protections in place for these women.
Okay, let's look at the relationship between lawyers and their clients, but from a consumer protection angle. The case of Bar of Indian Lawyers, through its president Jasbir Singh Malik versus D.K. Gandhi, PS National Institute of Communicable Diseases and ANARA addressed this. Can you sue your lawyer under consumer protection laws if you're not happy with their services?
That's what this whole case was about. A client said their lawyer hadn't done a good job, and they wanted to use the Consumer Protection Act to get some kind of remedy. Initially, the Consumer Court, the NCDRC, agreed with the client, but then the Bar of Indian Lawyers appealed to the Supreme Court. The Supreme Court looked at it and said that the relationship between a lawyer and a client is like a personal contract, and those types of contracts aren't covered by the Consumer Protection Act.
So basically, if you're unhappy with your lawyer's work, you can't use consumer protection laws to go after them.
Right. They said legal services provided by advocates don't fall under that law. So if you think your lawyer did a bad job, you can't use that specific legal route to try to get things fixed. But they did point out that there are other ways to deal with grievances against lawyers under the Advocates Act of 1961. That's where you go to complain about a lawyer's conduct or ethics.
Back to elections now. The case of Association for Democratic Reforms, ADR versus Election Commission of India, 2023, looked at the whole issue of verifying electronic voting machines, EVMs, with those paper trails, the VVPs. What were they asking the court to do, and what happened?
The ADR wanted the Supreme Court to order 100% verification of the votes. They said that just checking a small number of machines, like 5 per constituency, wasn't enough to be absolutely sure the results were accurate and transparent. They wanted every single paper slip from the VVPTs to be counted and matched with the electronic count.
Yeah, that sounds like it would really make people feel confident that the elections are fair. So why didn't the court go for it?
They said, look, we get it, transparency is important, but, and the but was basically all the practical problems. They said doing that would cause huge delays in announcing the results, it would be incredibly difficult for election officials to handle, and it just wouldn't be practical to count millions and millions of paper slips by hand. They pointed out that they had already increased the number of EVMs being checked back in 2019 to 5 per constituency. So they basically stuck with the current system, trying to find that balance between being thorough and making sure elections run smoothly and people trust the results.
All right, let's get into some financial law now. In the case of Rakesh Ranjan Shrivastava versus State of Jharkhand and Honor, 2024, the court looked at interim compensation in those cases where someone's accused of not paying a check, what they call check dishonor cases. Is the court required to award that compensation, or do they have a choice?
The question was about Section 143A1 of the Negotiable Instruments Act. Does it force the court to award interim compensation to the person who's saying they didn't get paid, or can the court decide based on each case? The Supreme Court said it's up to the court. They can choose to award it, but they don't have to.
Why not make it automatic?
They said that forcing interim compensation in every single case could lead to unfair results, possibly violating Article 14, which is about equality before the law. They said courts need to look at each case individually. What's the evidence? What's the financial situation of the person accused? It's about using judgment, not just handing out compensation automatically. So if you're ever involved in a situation where a check bounced, it's important to note that getting that interim compensation isn't guaranteed. It really depends on the specifics of the case.
Okay, last one, and it's about how the courts and the government interact. In State of Uttar Pradesh versus Association of Retired Supreme Court and High Court Judges, 2023, the court looked at this issue of judges summoning high-level government officials to appear before them. What did they have to say about that?
This was about the power of courts to call in people like chief secretaries and principal secretaries, basically top government officials, to show up in court. The Supreme Court said, hey, high courts, lower courts, be careful with this power. They issued some guidelines saying that these officials should only be called in when it's absolutely necessary for the case, not just to show who's boss.
Why did they feel the need to do that?
They said, look, the courts are here to make sure the law is followed, but calling in these high-level people all the time, it gets in the way of the government doing its job. It can really disrupt things, and it can also damage that important respect and balance between the courts and the government.
Interesting. So the courts are saying, we have power, but we shouldn't use it lightly.
Right. They said judges need to really think it through before they make these officials come to court. Is it really crucial for resolving the legal issue? If not, let them do their jobs. It's an interesting look at the separation of powers, how different parts of the government are supposed to work together.
One more case from 2023, and then we're done, I promise. Sharma versus Kishan Kumar. It sounds small, but it's about mentioning someone's caste or religion in legal documents. What did the court say about that?
The Supreme Court said don't do it unless it's really relevant to the case. Don't put someone's caste or religion in court filings just because. They said we need to avoid bias and prejudice in the legal system. Mentioning those things can make people think in stereotypes, and it can lead to discrimination.
Right. The court should be about the law and the facts, not about anyone's background.
Exactly. The court said focus on the legal arguments, the evidence. Only mention caste or religion if it's absolutely necessary to understand what happened. It's about making justice fairer for everyone.
And last but not least, a really big one, Sita Soren versus Union of India from 2024. This was about bribery and those special protections that legislators have called legislative privilege. What was the big question here?
The question was this. If an MP or MLA, a member of parliament or state assembly, if they take a bribe to vote a certain way or to give a particular speech, are they protected from being prosecuted? Can they say, hey, I have legislative privilege, you can't touch me?
This has been a tricky issue for a long time, hasn't it? What did the Supreme Court decide?
They were very clear. They said, no, a legislator who takes a bribe to do something in their official capacity, they're not covered by those special protections. They said the reason we have legislative privilege is so that legislators can do their jobs honestly, speaking and voting freely without being afraid of getting in trouble. But taking a bribe, that's not part of the job. It's corruption, plain and simple. And it goes against the very idea of democracy. So no immunity for that. And to make this crystal clear, they specifically said that an older interpretation from a 1990 HIP case, the JMM bribery case, was wrong on this point. The takeaway here is huge. Legislators are not above the law. They can't hide behind those special protections if they're taking bribes.
Wow. It's a powerful statement about accountability, isn't it? Well, we've covered a lot today. From interim stay orders to caste-based work in prisons and that huge ruling about bribery and legislative privilege, it's been quite a deep dive.
It has. These decisions really show how much influence the Supreme Court has. They're interpreting the Constitution, they're protecting our basic rights, they're making sure elections are fair, and they're pushing for a more just society. It's amazing how much these legal rulings can impact all of our lives, even if we don't always realize it.
We've talked about elections, about individual rights in the legal system, about making society more just, and hopefully we've made it a little easier to understand these big legal decisions without having to read through all those long, complicated documents yourself.
One thing that really stands out to me looking at all these cases together is that there's this constant struggle to find the right balance. The balance between protecting individual rights and making sure our institutions can actually function, for the good of everyone. So I'm curious, for you listening, as things change in our society, how do we keep finding that balance? It's something to really think about.
It is, and we hope you'll keep thinking about the things we've discussed today, especially as you read the news and trying to make sense of the world around you. Staying informed about these legal developments, it's a big part of being an active and engaged citizen in a democracy. Thanks for joining us on this deep dive.
Thanks for having me.